Good evening. I'd like to call the meeting, the Planning and Development Committee meeting to order of Monday, February 13th. We'll start with a roll call.
Roll call.
Present.
Councilmember Chair Kelly.
Present.
Councilmember Nusma.
Here.
Councilmember Reed. Councilmember Ravel. Here. Councilmember Wynn. Councilmember Kardagaris.
Here.
Great. So we have a quorum. We'll start. Can I get a motion to approve the minutes?
So moved. Second.
Okay, it's been moved and seconded. All in favor?
Aye.
Okay, so moved. We'll now move to public comment. And our first person is, and how much time?
Each person gets
2 minutes.
2 minutes. And the first person signed up. I don't know if we have any other paper sign-ins. If somebody could check that, that would be great. The first person signed up online is Karen Stover. She does not appear to be. Here, Karen Stover. Then let's move on to John Cleve.
Right. And I think I can be brief because most of you have heard from me. Saw you last week, and I want to talk. So I know that you're debating not the specific thing about connections, but more generally about making changes to the zoning. I do want to point out a couple of things that I hope will factor into your deliberations as you speak about these things. First of all, with the zoning ordinance that you're proposing, the amendments to be had there, it seems to me you have the horse and the cart in reverse order, in that, as I read it, you first get a special use granted to you, and then you have something like 6 months in order to get the operating agreement in place. It seems to me, shouldn't the Land Use Commission at all have the operating agreement in hand that's been agreed to by the city before you consider the special use? It seems like that's a critical piece that you left out. So I would reverse both of those. Secondly, and this time I am going very specific to connections and to the operating agreement that you have here. And this shouldn't be any surprise to you, Jonathan, because I sent this to you and Luke and some of the others. I think there are, and I'll be very brief about this, though I do have a handout to show it. I think there are 6 or 7 things in the operating agreement that renders it relatively useless. And one of the biggest things is there's no liability consideration in there. So if indeed there is a stabbing or some sort of problem that happens at Connections and there's a lawsuit, which has happened in a couple of our major cities, Evanston will be liable because they're going to definitely go after Evanston, and since Evanston condoned it, it's a problem. So we ought to spell out where liability falls vis the city or Connections for the Homeless. There's also nothing in the agreement about compliance. So you lay out all of these stipulations about that there's staffing, that there's this, that, and the other, but there's no language in the current draft of the operating agreement that stipulates what happens if it's found in violation. And therefore, the license agreement becomes worthless when it comes to the city trying to enforce its privileges. There's nothing in there about staffing other than they have 2 people on staff, one of whom is trained in security, though it's not spelled out what trained in security means. And so consequently, with the adequate staffing, why not, given that half of the homeless suffer from mental health issues, a quarter of them from serious issues, it's an issue. So what I'd like to do, if I have permission, is I make copies of those 6 items. Can I submit them to it for the record? Very good. Thank you very much. I appreciate the time to speak.
Thanks, John.
Thank you. And next we have
Cecile McHugh.
Hi, I'm here to talk about the ordinance. I'm in the right spot, right? The shared housing ordinance, right spot
Correct.
and time?
Yes.
Is that correct?
Yes.
Okay. I haven't had much time to put this together. If you'd be willing to give me a little extra time, maybe Karen's time, I'd appreciate it. Bill, go as fast as I can. And given a lot of time, I'm not super concise, but I'll go as fast as I can. I'm surprised by the speed at which this proposed ordinance, presented to the public for the first time last Friday, I believe, and slated to go on to the full city council meeting tonight, at that speed. I'm especially surprised given the scope of the changes, replacing an entire chapter of the municipal code affecting a good part of the city. I wonder how this ordinance came to be presented first to the P&D, bypassing the LUC. Two quotes from the city's website follows. The land use commissioner is responsible for, quote, ensuring the public health, safety, comfort, morals, convenience, general welfare, and objectives and policies of the comprehensive plan, end quote. Quote, the comprehensive plan is both a statement of community values and a list of recommendations for interpreting those values into future land use and blah, blah, blah. The plan aims to be comprehensive in addressing how physical aspects of the community affect social, economic, and environmental issues. I'll just go on. Isn't this proposed ordinance within the LUC's purview? The LUC's discussions and the time they give the public to comment and ask questions and receive answers is extremely important. Emphasis on receiving answers. That's the only place I've ever been that I get an answer to my questions. Please send this ordinance back to the Land Use Commission, that's possible, to give the public the opportunity they need to obtain information and provide input. Now, could I go on to my quick list of issues I see, but I didn't have time to address my most important
Go ahead
issue.
quickly if you can, please.
Yeah, which is a cap. There's no cap here on occupancy that I see. It's just as many people as you can cram in, 50 by 50 or 100, 100 square feet, what does that mean? If the Margarita Inn, we're not talking about it, but say there were, there was one residence per 100 square feet, how many people would that be? We need a cap, and there is a cap on transitional shelters in the code now. It is 30 people. And so that's really important. Let's see, I think that we need to know line by line why the text was modified in order to understand the effect of the proposed changes.
That's what you gave.
And I think we need descriptions of the proposed changes for each type of housing to understand what's being proposed. Am I out of time?
Yes.
You are out of time.
All right, thank you.
Thank you. And next. Gail Schechter.
I thank you for having me here. My name is Gail Schechter. I'm actually speaking in my capacity as the Executive Director of Housing Opportunities and Maintenance for the Elderly, or HOME, in Chicago. And we actually operate co-housing. I'm hearing people talking about connections, and I didn't know anything about this. I'm concerned about the actual unintended consequence of this proposed shared provider license. HOME, we actually have affordable intergenerational housing in which seniors live together, eat together with younger adults who are resident assistants and families with children at our Pat Crowley House and Natalie Salmon House. We do not have a license. This is not a medical model. It's simply, if you think of a continuum of independent living, with one end being, a single family home that you own, and another being, HOME's model, it's independent living, so we don't need a license. The only certification, I was thinking of what we have, is just for our cooks. So I think that you have to be careful in, having licensing for something that's simply another independent housing model. Secondly, if you do this, it may have a fair housing impact, and I'm wearing my hat now as the former director of Open Communities, where we were looking at this when the village of Skokie some years ago wanted to do a moratorium on group homes. This is obviously not that, but there's a similarity in that the village in that case was looking to, they were trying to impose a rule that would have had a disparate impact on people with disabilities. So considering that a lot of the people who might live in this housing are people who are members of protected classes, that the city might impose a rule that wouldn't be imposed on housing of people who are not in a protected class. It's just something for you to look at. So I think it's wonderful that you want to expand co-housing. It's a great thing. I loved your preamble and the citation of that Oak Park example, but I think it needs more study. Thank you.
Thank you very much.
Nobody else is signed up?
Okay, thank you, everybody, for your comments. Oh, one more? Okay.
I'm sorry. You were. I apologize. Donna Pugh.
Good evening, Donna Pugh with Foley and Lardner. Just on behalf of Connections for the Homeless, I only got 3 seconds.
No.
I
This is
just
a
wanted to say
reset.
that we're in complete support of this ordinance and this entire framework. So we thank you for doing that. Thank you so much.
Thank you. Okay, Mike Vasilko?
Thank you. Just quickly, I also am speaking on, I guess, P&D item D1, which to me, in addition to SP1 at the City Council, it's pretty clear that both of these are targeted to the Margarita Inn and Connections for the Homeless, the effort to change zoning for that particular project. So I'm confused because I read there was a judge's ruling that these issues couldn't be discussed tonight at council meetings. And it's on the agenda twice here at P&D and at SP1. And the woman who just spoke, made reference to the Margarita Inn and Connections. So, I guess I'm confused. How is it possible that our community development director can kind of sidestep a judge's order and the city is allowing these discussions to occur contrary to that order? So maybe the law department could comment on this. Thank you.
Thank you. Okay, that concludes public comment. Would someone, do we move an item for discussion? Okay, would somebody like to move?
I'll move ordinance 4023, amending portions of Title V, Chapter 2, lodging establishments of the City Code.
Okay, it's been moved and seconded. All in favor?
Aye.
Okay, nobody's opposed. Okay. We're not voting, so I wasn't sure if we needed to. We don't need to move it. Okay. All right, so Councilmember Nusma?
Thank you, Chair Kelly. I'd like to hear from a corporation counsel or community development director to just assure everybody that we have the legal authority to have this discussion tonight to address Mr. Vasilko's point. Sorry, my mic wasn't on. I'm gonna ask corporation counsel or deputy counsel to address Mr. Vasilko's question.
Thank you, Councilmember Newsman, Chair Kelly, members of Planning and Development Committee, Alexander Ruggie, Deputy City Attorney. Pertaining to whether or not we can discuss this item, the court order, the restraining order that was entered, the temporary restraining order, only pertains to Connections for the Homeless and Margarita Inn's application for a special use permit under the zoning code. The item before you here tonight is amending portions of Title V, Chapter 2. This is the Property Standards Code. It's not zoning code. And to also respond to another question posed, this did not go before the Land Use Commission as it's not a zoning text amendment. This is in Title V. It's not in Title VI, which is the zoning code. And the zoning code falls under the Land Use Commission's purview. So that's why this item is here tonight and up for City Council.
Thank you. With that, I'm wondering, Sarah, if you might be able to just kind of give us the background here.
Certainly. We have actually been talking about changing this particular part of the code going back to about 2015 when we really started looking at different ways to address housing affordability and the different ways people were living. If you go back through all those old charts and slides of everything, it was one of the things we talked about as a way of meeting new demands for the way people are living together, and we identified the need to update our very, very antiquated rooming house description, which really sounds like something from about the late 1900s, 19th century, to make it more compatible with, or give us the options of being able to consider different types of shared housing that would be coming up and were coming up, just as Gail Schechter pointed out. We didn't act on it. We talked about it a lot, and we wrote a lot of memos on it, but we never got to actually acting on it. If you want a brief summary of what we think are the benefits, I'll ask Liz to come up and just go over the benefits that we see that this provides from a standpoint of housing policy and development.
Good evening. Thank you, Interim Director Flax. So in terms of the proposed updates, in the memo this evening, they are intended to clarify all forms of shared housing situations. So there is a new definition that aligns shared housing licensing with the various zoning allowed uses, and basically establishes that they must obtain a license and be inspected annually. It is also intended to ensure that operations of facilities protect the health, safety, and welfare of occupants. Also allows for oversight that can address sites and operator-specific conditions to mitigate any potential impacts or negative impacts to the surrounding neighborhood. In addition, it provides a mechanism to proactively address issues that might arise. So there is a proposed process in the proposed code changes that allow for the ability to revoke licenses for noncompliance with property standards or the operating agreement that is now required by this proposal. And as Sarah mentioned, it also establishes a framework for which the City of Evanston can build upon as there are changes in the way housing is operated within our community. I want to point out that this proposed update does not change the types of land uses that are currently allowed within all of the various zoning districts across the city. It does not change occupancy levels or definitions of family within the zoning ordinance. It does require a process for reviewing proposed uses within each zoning district. So this is not changing that land use review when things require an administrative use, special use, or are permitted outright. And it also does not change building code requirements, property standards requirements, or other city policies or codes that we currently have within our regulations. So happy to speak to any more specific questions as you all discuss this item.
I see one of the benefits of this, if I could say it succinctly. This new model allows us to regulate a vast array of different types of housing, which the code considers under one category.
Correct.
And rather than trying to write one set of rules for a bunch of different types of housing, this allows us a customized approach via that operating agreement to write appropriate requirements for whatever future applicant might want to apply.
Correct.
Thank you.
Seeing
I'm
that
good for now.
Oh, okay. Councilmember Reed.
Yes, I first want to say that I appreciate the work that Councilmember Newsome and staff put into this ordinance. I do have a few questions, in part just response to public comment and just some of my own thoughts of how we formulate this. So can you explain the logic behind the square footage requirement? So I'm looking at 528, for example, where folks mentioned, every room occupied for sleeping purposes shall contain the following floor space: 70 feet per, for one person, 50 square feet per occupant for more than one person. So where do these numbers come from?
Sure. These are current standards within our property standards code, so there are no deviations from what is currently required of occupancy limits. And I believe that this is also pretty standard in terms of property standard requirements for other jurisdictions as well. But my understanding is this is the current requirement. There is no changes being proposed.
Correct, it's actually ICC code.
Okay. Yeah, thank you for that. And then I see the definition of shared housing, but I just want to be clear that, you know, let's say that folks were, you know, a bunch of roommates were getting together and they were going to share a lease and split the rent between each other. They would not be covered by this ordinance.
That is correct. That would be fall under the rental registration requirements and the requirements in zoning in terms of the number of occupants within a specific dwelling unit.
Okay, thank you. And last thing is, I am glad that we're moving this forward. I think when it comes to providing housing for folks, it is very important to have licenses in place for folks who are, you know, we want to make sure that we're providing the infrastructure for folks who are doing right, and we want to make sure that we have infrastructure in place for when we have providers that aren't doing right by their clients and by the community, and we can take away their ability to operate in our city. And I think this license structure makes sense here, and I think it makes sense for all residential housing situations where there's a housing provider. So, thank you.
Councilmember Ravel?
So do we currently license dormitories?
We do currently inspect and license dormitories.
Okay. And, I mean, and does Northwestern, for example, play a role, or do you contact the house manager? I mean, how do you do a dormitory?
Sarah, do you want to take that question?
I can address we inspect all the dormitories during a period of time before each school year starts. Very carefully coordinated so that we can get in there and do that.
I bet, yeah. And could you comment on Gail Schechter's comment about the co-housing program in Chicago, and that's really just a way for people to share their housing? I don't know, you know, that it seems a little different from these other housing examples in the ordinance. And I mean, I am actually surprised that we don't have co-housing yet in Evanston, because I became very familiar with it in Colorado, where my son was trying to get a co-housing project going.
I'll let Sarah speak to that.
I'm somewhat familiar with what Gail is talking about, because I've gone and toured some of their properties, and yeah, it's an amazing model. The purpose of this isn't to crack down on organizations that are doing things that are very straightforward. And quite frankly, the dormitories and things like that, yeah, we're going to license them. They're going to have a little thing of, say, how they operate. But we inspect all of our housing regularly, as I say. It's for anybody who's just doing a perfectly reasonable way of housing people. This should have no impact other than, I mean, it's the same stuff we already do for any kind of this sort of housing. We also inspect hotels. We inspect all of these things that are under this. And so I don't see it as being punitive or difficult.
Right.
Yeah. And I would say, in addition to that it would depend on the specifics of the operations in terms of the number of individuals that are living within that facility. We do currently have within the zoning ordinance limitations of the number of unrelated individuals living within a dwelling unit. So that, you know, is a current regulation that may impact that particular model for housing. However, I don't see how that fits into the shared housing licensing structure at this point, and it may be something in the future where we need to look at updating our land use allowances within the zoning code to further permit that type of land use. But as was mentioned, it sounds like it's just a family or a group of individuals living within a single family home, which would not be required to have a license for this.
My understanding of a co-housing arrangement is actually separate family units.
Correct, but the way she presented it this evening was that it sounded as if it was within one facility.
Okay.
So
Okay.
it may just be my lack of understanding of her
Okay.
model.
Great, thanks.
So I also have concerns about the disparate impact, and I think from what you just said, that sort of points to that this could in fact lead to disparate impact in terms of who's licensed and who's being, which group homes are subject to licensing. So like the example that Mr. Reed gave, that would not be, and others. So I am concerned about that. I do think licensing, there's a lot behind it, and I am concerned that this is being rushed through without proper, without sufficient vetting so that residents can meet with their council members, and I can hear from my constituents. I'm not happy that this is going through as a special order of business. But I also have questions. Many of the facilities listed under shared housing are, radically different. So these all fall under the same licensing, or where would I find? So for example, like a transitional treatment facility is radically different from a hotel, but it's listed under the same licensing. Are there separate licensing? Because I couldn't find those.
It would be the same shared housing license that would be required of those land uses.
So those are drastically different.
Correct, and one of the intents is to have that operating agreement that would specify the specifics of that particular facility and how that facility will be operated, recognizing that there are very vast differences in how these facilities do operate.
So the licensing will be the same for a transitional treatment shelter as from a hotel?
No, they could have vastly different operating agreements.
Operating agreement, but licensing.
The license is the vehicle of which we are reviewing the proposed use of that facility, and with that license is an operating agreement that is required.
Okay, because I've seen other cities that are very different, the licenses depending on the facility. So that concerns me that these are all falling under the same license, radically different facilities. I'm sorry, Councilmember Revelle, are you?
So where does it talk about the operating agreement?
5272. Top right on the third page. Third piece of paper. 1, 2, 3.
And I will note that any new license does require city council approval of that operating agreement when that new application is applied for.
Councilmember Revelle? Oh, you're not. Okay, and I was told by staff that this was being rushed through to accommodate Connections timeline, so that concerns me that we're rushing through something like licensing in order to accommodate the timeline for, and I know that's now changed, so I would like to see us take a little more time to ensure that this isn't actually having, the unintended consequences of undermining fair housing, or, unintended consequences that would lead to disparate impact. I do ask that we slow this down. Now that it's been special ordered, I know I can't hold it and this is only a discussion here this evening, it'll take 5 votes. I am, really discouraged and disappointed that we are forcing something through like this. What about our residents? What about our taxpayers? They should have the opportunity to really study this and discuss this, as well as all of us, and to meet with our residents at ward meetings. And I'm just very sorry that we're not going to, if this proceeds like this as a special order, we won't have that opportunity. So. Let's see, Councilmember Reed.
Yeah, this is on the agenda tonight at council for action, and I'm quite supportive of it. Yes, for introduction. I guess I'm seeking maybe a response from staff on what Councilmember Kelly just said. Is this a rush process? are we trying to align with connections, or are we just
So
getting in
yeah.
proper order in place here?
Staff was given a referral to bring this item forward, so I can't speak to this being rushed through on behalf of one applicant.
So I specifically, as chair, I asked, because I was trying to, I was wrestling with this ordinance, trying to understand it, and asked why this was being, pushed through so quickly as a special order, and I was told it was in order to accommodate the timeline for connections. So I just think at this point, since that's been slowed down, we should properly vet this and have a chance for, and again, I'm not opposed to it, don't get me wrong, I just think this isn't the correct way to proceed with such serious changes to our, and I understand it's not zoning, I understand that this wouldn't go through land use, but it should go through P&D and a proper, through normal legislative process, that's what I would ask.
If I may, Madam
Sure.
Chair.
Councilmember Newsma.
With regards to timing, I don't feel that this is rushed. It was actually intended to be on our agenda at one of the January meetings, but for procedural reasons got held until now. So we've been sitting on this for at least a month. And what's the relationship between this license ordinance and the pending issue with an applicant who shall be not be named at this moment? We do want future shared housing establishments to be licensed. We can't ask them to be licensed if we don't have a license. That's all that this does, is creates the structure for a future applicant to be licensed and allows us the flexibility, because this is a very broad category, which includes transitional treatment facilities and congregate housing and care homes and apartment hotels and dormitories, rather than writing a unique and separate license for each one of these categories. And it allows us to carefully construct and operate an agreement which is very unique to an individual applicant itself, not just a category of applicants. So as a regulatory mechanism, this structure really gives us, more authority and allows us to very finely tune our regulatory requirements to an individual applicant. So I'm fully supportive of this moving forward. I know it's on the council agenda, so I'm not sure how much more discussion we need to have now. We do have council at 7:30, so we could keep talking for half an hour if you want. But.
No, I think I've expressed my concerns. Again, I am concerned about the drastic differences between these different facilities and that they're all under the same licensing. I'm also very concerned about unintended consequences and the undermining of the Fair Housing Act. I do think this deserves more time. I don't think the way we're proceeding is proper, especially now that we have more time. So that being said, I think we can adjourn this meeting, unless there are any other questions, comments. Okay. All right. Do I need to? Okay, I move to adjourn the P&D meeting. All in favor?
Aye.
No opposed? Okay, meeting adjourned. City council meeting will start at 7:30. Thank you.